number 16. 16, Pramod R for appellant.
3 for the appellant, my lord.
Yes.
It is the owner's appeal, my lord. Where in this case, the liability fixed on the owner.
On the ground?
Liability fixed on the
On
owner.
the ground?
On the ground that, my lord, it is a agriculture policy and the tractor and trailer which was used for the commercial purpose, that is the one ground. And the driver of the vehicle is having the LMB motor vehicle driving license, my lord. That is the two grounds that has been dismissed. You Lordship, kindly see in the FIR it has been clearly stated, in order to construct the farmhouse, my lord, in the land of the owner, my lord, the wooden logs was taken to that particular place, my lord. Where the wooden logs were loading, one of the person has been fell down due to the moving of that particular tractor, my lord. That the injury was sustained and he has
Let's
an
come to
accident.
that, please come to the discussion part.
My lord, you lordship kindly see
Para
The-
20 of.
23, my lord. Para 23 is the finding of the trial court.
Read.
On the other hand, it is the version of RW2 ARTO that the separate driving license will be issued to the driver of the tractor and trailer. If the tractor and trailer are being used for the commercial or agriculture purpose, separate driving license will also be issued. As per Exhibit R3, driving license pertaining to the driver of the offending vehicle is not authorized to drive the tractor and trailer which are being used for the commercial or agriculture purpose. It is to be noted that though the learned counsel for petition has classified RW1 or RW2, nothing has been elicited disbelief there. The evidence of RW1 and RW2 clearly go to show that the driver of the offending vehicle was not authorized to drive the tractor and trailer involved in the accident, and the same is making use for the agriculture purpose. Admittedly, the policy issued in favor of the first respondent owner of the vehicle is the agriculture package policy. When such being the case, the respondent owner of the vehicle has breached the terms and conditions of the insurance policy. Considering the evidence of RW and RW material placed on the record.
So what is the case of the claimant?
The climate is that, my lord, he was loading the wooden logs in order to take to the land for construction of the farmhouse in the land, my lord. That is the agriculture purpose. That is farmhouse of the owner's land, my lord. That is, in order to construct that particular thing, wooden logs have been taken.
Where do you get such a big discussion on?
That is in FIR, my lord. That is not there, my lord. That is only the fact has been narrated. The group.
See, PW, FIR.
FIR
what
is
the
there, my
FIR
lord.
says?
FIR it is clearly stated, my lord. While taking the wooden logs to the construction of the house, farmhouse, at the land of the respondent, that is the appellant, my lord. While loading that particular wooden logs, my lord, he fell down when the tractor was moved by the negligence driving of
It belongs to the, if the owner is constructing a house,
farmhouse,
and-
my lord, in the land.
whatever it is,
Yes, ma'am.
when he's constructing a house, if the tractor is used for his purpose, it becomes agriculture purpose.
Yes, my lord. I would like to submit with regard to this, my lord. The farmhouse is being constructed for the purpose of having a facility to put some agriculture materials in that particular house, my lord. In every land, my lord, there is a farmhouse, my lord. That farmhouse is constructed would not be considered as a commercial purpose, my lord. If at all, my lord, if the wooden logs have been taken and wanted to sold some other persons, that would be the commercial purpose, my lord. Here in this case, my lord, the owner himself has.
For example, somebody is also, else is also constructing a farmhouse.
Yes, ma'am.
They are constructing a farmhouse. For that, you will use this vehicle.
Yes, ma'am.
Then what will it, then
That
also
is the commercial purpose, my lord. I do agree with that.
fine.
Why? Because, my lord,
It's agriculture purpose, because farmhouse is used for
that
agriculture.
is, my lord. If the farmhouse is not belongs to the owner, my lord, the question is when the vehicle used for the other than the purpose which has an agriculture purpose, if somebody else is putting the farmhouse,
In the policy, what are the agriculture purpose? What is, how is it defined? You appear for the insurance company.
Yes, madam.
Ah.
It is only for the cultivation of land and all.
Oh, that's what, is it any definition for that? What are the-
Elaborately, it has been mentioned only for
We'll have
agriculture.
that note and all, what is agriculture purpose?
My
they
lord,
would-
here, my learned friend has left out to point out that the defense entirely taken by the insurance company.
Mm.
Here, the insurance company has also pleaded that the injured was traveling as an authorized passenger in the tractor. That particular defense has been clearly discussed in para number 20 of the judgment. I permitted to read. The second respondent insurance company got examined his senior executive as RW1. He deposed the tractor trailer bearing number so and so was insured with the second respondent insurance company under the agricultural package policy. The said policy was in force as on the date of accident. Said tractor trailer involved in the accident is meant for agricultural purpose only, and the same should not be used for other than the agricultural purpose. The first respondent has willfully breached the terms and conditions of the policy. No premium was received to cover the risk of the employee except the driver. The petitioner was traveling as unauthorized passenger in the said tractor and trailer.
So
and
even
sustained
for
injuries.
agriculture purpose also, only the driver is covered as per the policy. Why?
Yes, yes, ma'am.
If there is a trailer, the loader and unloader will be covered. That's what is the law.
No additional premium has been paid, my lord. That is the reason.
Uh,
As per IMT 28, if they have been paid additional premium, then obviously he would have covered under the policy. Here, we have not received any
So
additional
driver
premium.
will only load and unload in a trailer.
More
You can
particularly,
understand,
yes, ma'am.
it's on the tractor. There is a trailer. If there is a trailer, somebody has to load and unload. They will be covered as per the policy.
My lord, here the petitioner was standing on the wooden logs loaded on the tractor, my lord. Trailer.
That is not the case. That is not.
Your lordship, you may kindly see the cross examination which clearly reveals that he was standing on the wooden logs which was loaded on the trailer. ಅಪಘಾತ ದಿನ ತಳಗವಾಡಿ ಹತ್ತಿರ ಮರಗಳನ್ನು ಕಟಾವು ಮಾಡಿ ನಿಂತಿದ್ದೆವು ನಾವು ಜೊತೆಯಲ್ಲಿ ಹಬ್ಬೂರು ನಿವಾಸಿಗಳ ಅಂಕರಾಜು ಮಂಜಾನಾಯಕ ಇದ್ರು ಟ್ರೇಲರ್ ಮೇಲೆ ನಿಂತುಕೊಂಡು ಮರದ ದಿಮ್ಮಿಗಳನ್ನು ಲೋಡ್ ಮಾಡುತ್ತಿದ್ದೆವು. That was the deposition and he was standing on the load of wooden logs, my lord. ನಾನು ಟ್ರೇಲರ್ ಮೇಲೆ ನಿಂತುಕೊಂಡು ಮರದ ದಿಮ್ಮಿಗಳನ್ನು ಲೋಡ್ ಮಾಡುತ್ತಿದ್ದು ಅಂಕರಾಜು ಮತ್ತು ಮಂಜು ನಾಯಕ ಕೆಳಗಿಂದ ಮರಗಳನ್ನು ಕೊಡುತ್ತಾ ಇದ್ದಾಗ ಟ್ರಾಕ್ಟರ್
Agriculture trailer.
That is the trailer, my lord. They are loading the things, my lord. They have taken the
Agriculture trailer tractor.
that is not
means-
moving. That is not.
Agriculture tractor means any mechanically propelled four-wheel vehicle designed to work with implements for various field operations and
Yes, ma'am.
trailers to transport agriculture material.
Yes, ma'am.
Agriculture tractor is a non-transport vehicle. Agriculture trailer means a trailer generally left uncovered with single double axle construction which is coupled into an agriculture tractor. So and so now what are you transporting are the logs.
Wooden
They are
logs.
for the agriculture purpose.
That is for the construction of a farmhouse in my land.
that is the say of the claimant.
That is my-
If in the cross
Yes, please
examination, he
Yes,
clearly admitted that it was for the selling purpose they are
Yes,
cutting
before
the
this
trees.
court.
And one more submission is
Agreed with
that
orders passed in
one more
MBC number.
submission is that, my lord, it will never comes under the commercial purpose. Because of that, the policy which does not say with regard to that, this would not comes under the commercial purpose. This would comes under the commercial. One more thing, my lord, they other side is submitting that is traveling in the tractor, my lord. That is not traveling in the tractor, my lord, and is just loading the wooden logs, and wherein the tractor was moved and he fell down on the spot itself. He has not moved, my lord. So with regard to that submission, my lord, even if it is the land is belongs to the owner, my lord, Paramos is nothing but the part of the.
That you submitted, that I understood.
Yes.
My lordship, my humble submission is
MBC number.
no material has been placed on record to show that the wooden logs were used for the purpose of the owner constructing the house.
Passed in MBC number
And also in the
1114.
cross examination, he clearly admits that it was for the
Understand, and the
selling
court is
purpose.
with you, why do you want to
Please,
argue?
sorry.
Agreed with orders passed in MBC, agreed with the dismissal law. Agreed with the orders passed in MBC number 114 of 2014 dated 6 March 2015. The owner of the vehicle is before this court. Agreed by the finding that of the court that the owner is liable to pay the compensation. The case of the claimant was that on 25/7/2013 at about 5:30 p.m., the claimant was in the process of lowering the wooden logs to the trailer. At that time, the driver of the tractor and trailer all of a sudden moved the tractor in a rash and negligent manner, and the claimant has lost control, fell down from the trailer. Then the wheels of the trailer ran over his left leg, and a result of which he sustained grievous injuries. The tribunal had granted the compensation, and when it comes to the liability, the court has held that it is the owner alone who is liable to pay the compensation. While coming to such conclusion, the court has observed that the driver of the tractor is not authorized to drive a tractor trailer. Further, the policy is given for the agriculture purpose, and the same is used for a non-agriculture purpose to transport the logs, wooden logs. It is a case of the insurance company that the he is an unauthorized passenger and is sitting on the logs in the trailer. The tribunal has observed that there is a violation of terms and conditions of the policy, and the owner alone is liable to pay the compensation. Next one. Land counsel appearing for the owner of the vehicle submits that the tribunal had failed to consider that the tractor is used for agriculture for purpose for constructing the farmhouse tools, and it cannot be termed as a non-agriculture purpose. It is further submitted that the loader and the unloader cannot be termed as a gratuitous passenger. Further, that the LMB transport and non-transport also cannot be a ground for the court to fasten the liability.
Laden weight is,
Huh?
laden weight of the tractor and trailer is less than 7.
Is not the ground, and in the light of the law laid down in Mukund Degan, the insurance company is liable to pay the compensation, but not the owner of the vehicle. And counsel appearing for the insurance company submits that all the argument that is put forth before this court was never the case of the owner of the vehicle. He has not placed any material before the court to show that the vehicle is used for the purpose, for the agriculture purpose. He submits that even assuming that the purpose as stated, it cannot be termed as an agriculture purpose, and when there is violation of terms and conditions of the policy, the insurance company is not liable to pay the compensation. Having heard the counsels on either side, produce the material on record. The vehicle is insured for the agriculture purpose, and it is an admitted fact that the same is the vehicle is used for carrying the logs for the construction of a farmhouse. According to the learned counsel for the petitioner appellant, construction of a farmhouse is an agricultural purpose, and the court had failed to appreciate the case of the owner of the vehicle. And according to the insurance company, the claimant, the owner of the vehicle, has not put forth any material before the court that it was used for the agriculture purpose. This court is not able to appreciate the contention advanced on behalf of the counsel for the owner of the vehicle that construction of a farmhouse is agriculture purpose, and there is no violation of the terms and conditions of the policy. In the considered opinion of the court, it does not amount to agriculture purpose, and the tribunal has rightly held that there is violation of terms and conditions of the policy, and the owner alone is liable to pay the compensation. Accordingly, the appeal of the owner of the vehicle is dismissed and the amount in deposit shall be forthwith transferred. Yes, next.
Submission, my lord, sorry, my lord, I was held up in some other court. Page number 15, my lord, last matter.
Uh,
Not, I have taken the draft of the paper publication, my lord, but it has not been published in the paper, my lord. Because of the communication gap, my lord, I could not contact to the party, my lord.
So what is to be done now?
I will do, my lord, kindly extend the time, my lord, to
Permitted the same, on the same condition, give that date, tell him the dates. He should also know.
5/6, draft
Publish.
23rd April, hearing on 5/6.
Yes, next.
publish.
Hmm. Yes,
Case number 8, Stain Srinivas.
what do you say?
Your Lordship, astonishingly, this case is 73 of 2006. The cost title and the parties are different.